Hello, I'm attorney Dan Marr. I've been practicing law in New Hampshire for approximately 36 years and in Massachusetts, the Commonwealth of Massachusetts, for about 28 years. And during that period of time, I've dealt with a variety of issues, including representing businesses in employee issues. And today's vlog, I'm going to be talking about what happens when you get a claim brought against you from the Department of Labor. We're going to go to New Hampshire this time, but similar in Massachusetts. I've dealt with both, for a claim as to unpaid bonuses or unpaid commissions. So an employee leaves your company, they usually are not doing this while they're still employed with you. They're making a claim against you. Either you fired them or they went off on their own, and sometimes it's a difficult time because they're also at a competitor and now they're looking for commissions or bonuses. So we're going to talk about that in this program. I'm here at the national law firm of Hamlin and Kerrigan, right on the border of Massachusetts and New Hampshire, and I've been practicing and doing this for quite some time. In New Hampshire, one of the things that the employee first can do, and they make their own election on this, they can either go to the New Hampshire Department of Labor, that's off of Pleasant Street in Concord, New Hampshire, or they can file in the Superior Court. They have the right to do it in either location. My experience is often if it's a larger claim and there's some discovery that needs to be done, the employer is probably going to hire an attorney and file a claim in the Superior Court. And that means that you'll then have some discovery be done. Maybe it's regarding the whether or not they've earned the commissions or the bonus, and we'll talk about that in a moment. But if you're in the Department of Labor, it's less discovery, and you're going to get a hearing sometime as early as 2 to 3 months after the filing of the claim. So it moves faster in the Department of Labor. Department of Labor, if there's a claim brought there, there's a hearing officer that will listen carefully to the questions. One of the things that the hearing officer does is they obviously want you to strictly comply with the rules. If you have compensation, you're supposed to be putting it in writing. You're supposed to provide it to the person. So if you have a commission agreement, you want to bring that with you. You want to explain that to them. If you have any communications with this employee in regards to this, you want to bring that to them. If they're management themselves, so they're in a say they're a sales manager, and they've dealt with this issue with other employees before, and they've agreed with you in regards to how to deal with other employees before, you want to address that issue too. So you want to come up with, you want to deal with the issue of what this person really understood was the commission or the bonus structure for that matter. Bonuses sometimes are set up in a more discretionary manner. You want to very clearly explain to the hearing officer or the court as much discretion that's shown in this document, that if you have some discretion in regards to whether you provide a bonus or whether you provide the commission, you want to explain that, and you want to provide the writing on that. And one of the big things I want to point out in this process is don't take it lightly. Even if you think that the claim is bogus and you're irritated and you want to be dismissive of this person, don't be dismissive. A hearing officer is going to be looking more to protect the employee. Generally, that's what their goal is to protect employees with rightful claims. So you want to make sure that the hearing officer gets to see why it is not a rightful claim. It's not a proper claim for them to grant. So you want to give it all nice and easy for the hearing officer. If there's lawyers involved in the Superior Court, and it's usually lawyers involved if there's 2 lawyers, and it's usually happening in the Superior Court, sometimes the employer will have a lawyer in the Department of Labor, and the employee may be pro se, and that may help you, that may not help you, because the hearing officer might be more inclined to help the not represented employee in that situation, but that's something you talk with your attorney about. In these situations, though, you want to make it as extremely easy as possible for the decision maker, the hearing officer, or the judge to find in your favor. Put it all out there, all the facts in there. If there's witnesses that have tested, bring those witnesses with you to the hearing at the New Hampshire Department of Labor, saying that Jack, the claimant, knows this is the way the commissions was because he told me this. And when he was the sales manager, he knew that that's the way we handle these things. So sometimes the issue comes about as to, in sales commissions, whether or not you earn that commission for orders that are not booked and paid for until after the person leaves. So they're accepted by the company beforehand, but then it's not booked, and or it's not actually done and shipped and paid for until after the employee leaves. Generally in New Hampshire, the laws, unless you have a clear policy or something in writing that's a contract to the contrary, it is considered earned when it's accepted, subject to divestiture if the customer doesn't pay or the shipment doesn't go out, but it's earned then. So an employee in May of 2024 went and booked this and it was accepted, and they left the company in June of 2024, and the shipment didn't go out until August of 2024, and therefore you weren't paid until August of 2024. Absent there being an agreement or a policy, the New Hampshire Supreme Court has made it quite clear that that has to be paid. So you want to make sure you have all those explanations as to what's going on in there, and take the time to do the details. I've dealt with these quite a bit. I've dealt with the issues also as to the financial details, as to bonus calculations, and the financial details if there's some net sales. If it's not just a straight, you get X% per customer order, but it's still some net profits. I've dealt with all those complicated matters. It's important to spend the time with those if they are substantive to you, to your business. If it's a small matter, you might set it up, but talk to your attorney about this. I've done this. This is Attorney Dan Marr at 603-883-5501, 603-883-5501, or you can check out our website, naturalaw.com. I've done weekly vlogs, and I'm happy to talk to you, and you can look at those. And I look forward to the opportunity of working with you. If the opportunity does arise, you can call, and assuming that we don't have any conflict, we can talk it through, and you can then make a decision as to whether you want to have assistance in regards to defending this claim. Thank you.